Hello all, welcome to Legal Talks by Desi Kanoon. I am Suyash and I am excited to have started this show. On today's show, we will talk about yet another important judicial pronouncement by the Supreme Court of India, wherein the Honorable Supreme Court of India took suo motu cognizance and provided for guidelines regarding inadequacies and deficiencies in criminal trials. In this case, the court took note of various deficiencies that occur in the course of criminal trials and certain practices adopted by the trial courts in criminal proceedings. It is pertinent to note that the Honorable Supreme Court had taken up this issue regarding deficiency in criminal trials earlier in the year 2017 as well, and upon years of deliberation and consultation, Draft Rules of Criminal Practice 2020 was formulated. According to the court, such rules are in no way repugnant to the existing criminal procedure laws such as the Code of Criminal Procedure 1973. Before adverting any further, let us understand the Draft Rules of Criminal Practice 2020. Now, it is important to understand these rules as it is based on these rules that the court has provided for various other guidelines in this case. The Draft Rules of Criminal Practice 2020 provide for the following important points. It provides for body sketch to accompany medico-legal certificates, that is MLC, post-mortem reports and inquest reports. It also provides that there must be photography and videography of post-mortem in certain cases. Further, it provides that spot panchnama of the place of occurrence of the crime should also contain a site plan indicating various details such as the place where the body was found, source of light, elevation of the structures that is in the place of incident, etc. The draft rules also provided that the accused is to be supplied with statements of witnesses recorded under Section 161 and Section 164 of the Code of Criminal Procedure 1973, along with the other documents under Section 173, 207, 208 of CRPC. Usually, the accused is not supplied with the documents on the basis of which the prosecution is proceeding against him or her. But according to the draft rules, such documents and statements must be supplied to the accused. Now, we also know that there are various forms that are provided in the various schedules of CRPC, and usually these forms are not followed by the presiding officers or the judicial officers. In the draft rules of criminal practice, it has been provided that the order framing charges shall be accompanied by a formal charge in Form 32 of Schedule 2 of CRPC. It also provides that the deposition of witnesses shall be translated into English and will be read over mandatorily by the presiding officer in court, and a free true copy of the same shall be supplied to the accused, the witness and the prosecution on the very date of recording. The record of depositions shall indicate the date of the chief examination, cross-examination and re-examination, and can be done in question and answer format if found necessary. The draft rules also stated that any objections while recording of evidence shall be reflected in the recording of the evidence and decided expeditiously. Sometimes the objections are raised by the opposite counsel or the other party, and it takes days if not months to decide such objections. So such practices are to be deprecated. Further, we have seen that the record of criminal trials is quite voluminous and it becomes difficult to find relevant documents and segregate them in an orderly fashion. So in this regard, according to the draft rules, it has been stipulated that the exhibit numbers shall further show the witness number after the exhibit number. We know that the documents are given exhibit numbers when they are presented before the court, and these exhibits are usually presented by various witnesses. According to the draft rules, it would be better if the witness number is also further shown along with the exhibit number. The draft rules also stipulate that after framing of charges, the accused persons shall be referred to only by their ranks in the array of accused and not by their names. Even the exhibits and the deposition of witnesses shall be referred to by their numbers and not by their names or other references. I think this is a very welcome suggestion in the draft rules, as there must be uniformity while referring to various witnesses or the accused persons. If sometimes names are used and if sometimes their numbers are used, then it becomes very confusing to relate them. It is also pertinent to note that the relevant portions of statements under Section 161 or Section 164 of CRPC or the exhibits that are used for contradicting or corroborating the respective witnesses should be extracted and indicated in the deposition. These relevant portions must be extracted and indicated in the deposition, and the admissible portion under Section 8 or Section 72 of the Indian Evidence Act shall be marked and extracted on a separate sheet and given an exhibit number. The 11th point in this regard is that every judgment shall contain the details as provided in the format appended to the rules and contain the list of witnesses, exhibits, and material objects. Basically, when you read a judgment, sometimes it becomes very difficult to correlate from where the story is starting and where it is ending. So, in order to avoid such disputes, it is better to have an index before the judgment starts, and this index can contain the list of witnesses, exhibits, and material objects. Further, all judgments shall contain the points for determination, the decision and its reason, and in case of conviction, it shall separately indicate the offense and the sentence therein. In case of acquittal, a direction shall be given to set the accused at liberty unless such accused is in custody in any other case. 13th, even in judgment, names shall not be used and only numbers and the nomenclatures indicated herein above, that is, the ranks in the array of the accused or in the array of the exhibits, shall be used. 14th, bails must ordinarily be disposed of within a period of 3 to 7 days from the date of first hearing. It has been seen that these days bails take a lot of time to decide, and so, according to the draft criminal rules, the bails must ordinarily be disposed of within a period of 3 to 7 days from the date of first hearing, and reasons for any such delay must be mentioned in the order itself. Further, copy of the order and the bail application must be furnished to the accused on the date of pronouncement of the order itself. Thus, the draft rules make it unequivocal that the copy of the order has to be supplied to the accused free of cost on the date of pronouncement of order itself. There cannot be any delay in this regard. 15. The draft criminal rules suggest that more criminal advocates should be appointed to assist the prosecution, and day-to-day hearing of all trials should be conducted, and any delay in terms of Section 309 subsection 1 of CRPC must be recorded. Thus, if day-to-day hearing cannot be conducted and if there is any delay, then the reasons for such delay must be recorded. If the witnesses are in attendance, no adjournment should be granted except for special reasons to be recorded to in writing. And lastly, there is a very important suggestion and an interesting one too, that sessions cases should be given precedence over all other work, and no other work should be taken up on sessions days until sessions work for the day is completed. We all know that usually in Indian courts there are two types of cases, civil cases and criminal cases. The criminal cases could also be called as sessions cases. So according to the draft criminal rules, sessions cases should be given precedence over all other work. Now, why is that so? What is the reasoning behind it? I think the reasoning behind it is that in sessions cases, the life and liberty of a person is at stake. So, we will talk about this in greater detail in the next post, wherein we will discuss what all the Supreme Court had to say in regard to this draft criminal rules. Thank you and stay tuned.